Former federal prosecutor and former assistant DA in Cobb County, Georgia, Francey Hakes, and former U.S. attorney for the Northern District of Alabama, Jay Town, joins me. Francey, I mean, so, every night after 5 o'clock, I'm sorting through so many emotions, my head is spinning. So tonight, it's a little bit of a win, I suppose, for Mark Meadows that they're expediting it. On the other hand, I guess it's a win for Fani Willis, too, because she wants it to get done quickly, of course, in her favor, and he wants his favor.
Well, it's interesting, Greta, because I wonder if we can do what Jay did, I saw the other night on your air, talking about reading the tea leaves because of what the 11th Circuit does. What's interesting here is that they have granted his emergency stay. Normally, an appeal might take as long as a year or even 18 months with respect to briefing schedules and reply briefs. But here, the Court of Appeals has requested all those briefs to be filed in September, which is lightning speed for the 11th Circuit or any other federal court of appeals. And so I wonder whether they feel like that appeal might be well taken, because, of course, they know the substance of it from Mark's brief. So I wonder if it means that the Court of Appeals thinks that they might grant Meadows' motion, and so they do not want to get into the issue of he's going to trial in October while they're hearing the appeal, so they're hearing it early.
Well, I suppose, though, Jane, I suppose this would be a nightmare for everybody, is that the Court of Appeals could issue a stay, or they could tell Georgia, I assume, maybe that you can't go forward. I don't know if they have the authority to do that, so they can maybe put the brakes on Georgia. But if reading the tea leaves like Francey, is that if I had to guess, this is a better position maybe for Mark Meadows to be in than Fani Willis, but not necessarily so.
Well, Greta, what I'll
Jay?
say, what I'll say is that you're absolutely right. I do think those tea leaves matter. And the briefing today, as it related to the removal statute and applying to former officers, I'll say this, and I mean this in all sincerity. Fani Willis has a very casual relationship with the removal statute, the tenets of immunity, and constitutional law. If she stumbles into a law library someday, she might learn that there was two words she didn't use throughout her briefing today: supremacy clause. The reason why we remove federal officers and officials from state court for acting in their official capacity is because of the supremacy clause. I'll give your viewers a great example, and you know this. A DEA agent makes a controlled buy, sells a kilo of cocaine to a drug kingpin. They swoop in, they arrest the kingpin, the DEA agent gets a medal. Under Fani Willis's legal theory about former officials, if that DEA agent retired tomorrow, she could indict him tomorrow for selling dope. That's absurd. That's not immunity. That's a tolling of the statute of limitations in Georgia. And it's certainly not the supremacy clause. So again, I think that Mark Meadows is on great solid ground here, and he and his lawyers are really going to blaze a trail for the other 18 defendants.
All right. Well, I'll tell you what I think is a little bit funny. I'm, looking at the brief filed by these are the lawyers for Mark Meadows, and in it they have what's a certificate of service saying who that they've sent it a copy to. And and I thought, well, I looked through the certificate of service and had Cynthia Oxney, whose name I know from around D.C., Erwin Chemerinsky, whose name I know from UCLA Law School. And I thought, what in the world do they have to it? Well, they have filed a friend of the court brief, but the thing I like the most is how they describe themselves. They're former prosecutors and federal court scholars, and they say that in case the Court of Appeals needs help. Now, I mean, it's just stunning to me. They're respectfully submitting so they can help the Court of Appeals. Why are they sticking their nose into this, Francey?
Well, that's a great question, Greta, because I promise you I've argued in front of the Court of Appeals before at the 11th Circuit, and they're a bunch of smarty smarts. They don't need the help of anyone who calls themselves a scholar or not. The Court of Appeals will know the law, and they will apply to the law to the facts, and I have confidence that they'll do it in a fair way. I don't think that Judge Jones gave Mark Meadows a fair shake at the district court level at all, and I think you can see that in his kind of rude denial of his motion for a stay. Most judges would grant that. They would grant a stay of their order temporarily while the case goes up on appeal. It's obviously appealable, and the fact that he didn't speaks volumes.
All right. Well, I just
think
love the modesty of the lawyers. I love the modesty of the lawyers who refer to themselves as federal court scholars and are going to help the Court of Appeals. Jay, we'll have to talk about this tomorrow because I got to go. Francey, Hakes, Jay Town, thank you both.